accepting your amendment.
With the greatest of respect to the Minister, your response doesn't make sense, because under the provisions of the legislation as before us, the county manager could nominate any number of members of his staff to have access to this information. And implicit, Minister, and I'm sure you mean no offence to local authority members, but implicit in your response is the view that the mayor or the Cathaoirleach of the County Council cannot be trusted. That's basically what you're saying. You're saying that it's fine for a director of service or any number of directors of service to have access to the information, but it's not fine that the member that has been elected and that is the official face of that local authority, it's not fine for that person to have, where it might be necessary, access to the information. And I think that's where we would have a fundamental disagreement with each other on this particular matter. Again, I'd ask you to reconsider your position.
This is not about trusting Cathaoirleachs or mayors, whatever. You're talking about volunteers of an organisation that are coming in, given freely of, it could be medical records, their own personal details. And I don't believe, personally I don't believe, and as outlined the advice from the Data Commissioner, is that that information should be freely available to anybody. And as you're well aware, that the county manager or city manager will appoint a person with specific responsibility for the civil defence board in his or her own city or county, and that is the person that will access on occasions to the personal records of any volunteer member. But I think we have to recognise it's the volunteers that are in the organisation at the moment and the volunteers that we hope will join the organisation going forward.
I'll be very brief. I mean, again, the county manager can appoint anyone he likes from within his staff, anyone, or any number. There's no limit in the legislation on the number of people he can allow access to this particular information. I'm simply advocating that the mayor or Cathaoirleach of the local authority should, if necessary, have access to the information. Whether the people are volunteers or not has absolutely no bearing whatsoever on who might access it. And I don't accept your point at all that allowing the mayor or the Cathaoirleach to have access is in some way throwing the doors open, publishing the information on a wide scale. And I couldn't see any reason why the Data Protection Commissioner would have any difficulty with the mayor having that particular information where it's necessary. And it comes back to that, where it's necessary.
Again, Deputy, I understand your endurance to this amendment, or your how strongly you feel on it, but unfortunately I won't be accepting the amendment that you have stated are put in front of us.
I put the question. The question is that amendment number 4 in the name of Deputy O'Farrell, that the amendment be made and the Teachtaí atá I have the Tarishkin Abdish Ta, Teachtaí atá and the Kina Abdish Nia, Sheedam Gunning, Guil Butcher and Gesht. The amendment is defeated. That completes the report stage. We now move on to 5th stage, and I ask the Minister to move that the bill do now pass.
I move.
Is that agreed? Agreed. A message will be sent to the Shannon acquainting is accorded. Thank you very much.
I would like to thank all the deputies, both in the Dail and Shannon, for their comments during the course of the debate at all stages through the House. We had some very good contributions in both houses, and I very much appreciate people's contribution. I also like to thank the officials for their work they put into this bill in the Department of Defence, and I know that everybody recognises the importance of the work that the civil defence do and will continue to do. And I'd like to wish all the civil defence members across the country a very happy Christmas and a peaceful New Year.
Thank you, Minister. We now move on to the Civil Registration Amendment Bill 2012, all stages. 2012, Shannon, could I call in the Minister for Social Protection, Deputy Joan Burton, to move the second reading, that the bill do be now read a second time?
I move that the Civil Registration Amendment Bill 2012 be read a second time.
Thank you.
I realise that we four are probably all alone in the Dail at this point in time, but I suppose as Christmas is coming, it's an appropriate time to have a bill which proposes to extend the celebration of marriage. And in that context, while we won't have Christmas weddings in terms of humanist weddings, I think we might actually, subject to the enactment of the bill and its signing off and so on by the President, we may well get to Whitsun weddings, which will be celebrated by humanist celebrants or solemnisers. So I want to outline the context for the bill. The Civil Registration Act of 2004 provides for the notification, registration and solemnisation of marriage. Under this Act, only the Health Services Executive, the HSE, and religious bodies can apply for registration in the Register of Solemnisers established under the Act. The bill will amend that Act by providing for an extension to the type of organisation that can nominate marriage solemnisers to include secular bodies. In Ireland, marriage and the family unit are central to our constitution and are also very much part of our social fabric. When two people make a public commitment to each other by way of marriage, it is a cause of great celebration. It is one of those occasions when not only do people wish to have their family and friends around them, but they also wish to celebrate in the belief system that they hold dear. The bill before us today aims to extend the scope of marriage solemnisers across the spectrum of belief systems and to formally acknowledge this in our registration system. I now propose to offer some general observations on the rationale and general principles informing the content of this amending legislation, and then proceed to summarise the provisions of the bill. The marriage provisions of the Civil Registration Act of 2004 arose from recommendations of the Interdepartmental Committee on the Reform of the Marriage Laws, the IDC. The need for a universally applicable framework of clear and simple procedures to underpin the solemnity of the marriage contract was among the issues identified by the committee as requiring examination. The main provisions of the Act concerning marriage are to provide for common preliminaries and a single set of documentation for all marriages, the introduction of the marriage registration form, that's a single licensing system, the establishment of a register of solemnisers, and provision for a choice of venue for civil marriages. Section 51 of the Act provides that a marriage may only be legally solemnised by a registered solemniser. Section 53 of the Act provides for the establishment of a register of solemnisers. Section 54 provides that a religious body or the HSE may apply to have a member of that religious body or a registrar, respectively, entered in the register. It's clear that many of our citizens wish to celebrate their commitment to each other through a non-religious marriage ceremony. And I think these statistics will interest the Dáil. Out of the 19,828 marriages held in 2011, almost 6,000 were civil ceremonies. This represents 29% of all marriages performed in 2011, and that compares to a figure of 6% of marriages being civil ceremonies way back in 1996. In 2011, there were 5,413 religious solemnisers and 113 civil solemnisers registered in the Register of Solemnisers to conduct valid marriage ceremonies. This Act will provide that valid marriages can be performed by bodies that fulfil the criteria of a secular body as laid down in the Act, reflecting the varied belief systems in a modern society which still holds marriage as a very valuable life choice. In this regard, the Civil Registration Amendment Bill of 2012 extends the definition of the term body in relation to marriages to include also a secular body. The bill sets out criteria which must be met by a body before it can apply to have one of its members solemnise marriage. While this limits somewhat the bodies that would be eligible, it respects the obligation of the state to safeguard the institution of marriage and ensures that the bodies involved be stable, long-standing and reputable organisations. The body must be in existence for at least 5 years. It has to be an organised group of people who have secular, ethical and humanist beliefs in common. It must have a minimum of 50 people, and it has to meet on a regular basis. The body must have an entitlement to an exemption under Section 207 or 208 of the Taxes Consolidation Act of 1997 and cannot have the making of profit as one of its main purposes. In addition, there is a list of organisations which are deemed, for the purposes of the bill, not to be secular bodies, and these include chambers of commerce, organisations that are political, sporting, athletic, trade union, representative in nature, and bodies that promote purposes that are unlawful, that are contrary to public policy or morality, that are in support of terrorism or terrorist activities, or for the benefit of an organisation of which membership is unlawful. The body will be required to meet the criteria on a continuous basis and will be obliged to inform An Táir Cláraitheoir, the Registrar General, if they cease to do so. In the event of the body not meeting all of the criteria, the body's members will be removed from the register of solemnisers. There is scope within the Act to allow for appeals and reinstatement on the register where it is seen fit. In amending the Civil Registration Act of 2004, this bill adds in the concept of a secular body to those sections that had previously provided for a religious body. I now want to summarise the main provisions of the bill, and in doing so, I do want to acknowledge the work done on this particular bill by the Upper House and indeed by my own party colleague, Senator Ivana Bacik. But also to say as well that we have many religious bodies defined in relation to solemnising marriage, including, religious bodies that a lot of us wouldn't be familiar with, as well as all of the major religions. So the bill then, Section 1, the definition of the terms of the Principal Act used throughout the bill as a Civil Registration Act of 2004. Section 2 amends Section 45 of the Principal Act and inserts and modifies definitions in the Principal Act to provide for the broadening of the type of bodies that can apply to have a member added to the register of solemnisers by including secular bodies. Section 45 provides for the definitions used in Part 6 of the Civil Registration Act of 2004, which relates to the amendment of the law relating to marriages. At present, this section only provides that a religious body and the executive, i.e. registrars appointed by the HSE and who are included on the register of solemnisers held in the Registrar's General Office, can conduct valid wedding ceremonies. This amendment and the insertion of Section 45A, as provided for in Section 3, will allow bodies who fulfil the criteria of a secular body as defined to conduct valid marriages. Section 3 amends Section 45 and sets out the interpretation of the definition secular body for the purposes of this bill. For the purposes of this part, a body shall be a secular body if it has not fewer than 50 members, its principal objects are secular, ethical and humanist. Members of the body meet regularly in relation to their beliefs and in furtherance of their principal objects. Any rules regarding marriage or the solemnising of marriages do not contravene the requirements of the Act or the law. It is shown to the satisfaction of the Registrar General that it has appropriate procedures around the selection, training and accreditation of solemnisers. It has been in continuous existence for at least 5 years. It has for at least 5 years an entitlement to an exemption under Section 207 or 208 of the Taxes Consolidation Act of 1997, in respect of which a number stands issued by the Revenue Commissioners for the purpose of that exemption, and that number stood issued for a continuous period of 5 years immediately preceding the date of its most recent application, does not have the making of a profit as one of its principal objects, maintains a register of members. In addition, this section provides for a list of bodies which are deemed not to be secular bodies for the purposes of this part. These are as follows: a political party or a body that promotes a political party or a candidate, a body that promotes a political cause, an approved body of persons within the meaning of Section 235 of the Taxes Consolidation Act of 1997, a trade union or a representative body of employers, a chamber of commerce, a body that promotes purposes that are unlawful, contrary to public morality, contrary to public policy, in support of terrorism or terrorist activities, whether in the state or outside the state, or for the benefit of an organisation, membership of which is unlawful. Section 4 provides for the amendment of Section 51 of the Principal Act to include solemnisers from secular bodies in the requirements to be met for a valid solemnisation of marriage. Section 51 provides that a marriage may be only legally solemnised by a registered solemniser. It sets out the elements required to be met so that a valid marriage takes place. Section 5 provides for the amendment of Section 53(4) of the Principal Act to allow the Registrar General Ard Clorahor refuse to register a person if he or she considers that the body concerned is not a secular body. Section 53 provides for the establishment of a register of solemnisers to be maintained by An Ard Clorahor. The register holds the names of all solemnisers who have been approved to conduct valid marriages, and the register is open to inspection by the public. Section 6 provides for the amendment of Section 54 of the Principal Act to include secular bodies in the category of bodies that may apply for registration of persons on the register of solemnisers. An officer of the secular body must sign a certificate to the effect that, in their opinion, the nominated person is a fit and proper person to solemnise a marriage, and confirms that the nominee has been selected, trained and accredited by the secular body in accordance with their procedures. The section also sets out procedures in relation to requesting additional information from bodies regarding an application on behalf of a member to become a registered solemniser. Section 7 provides for the amendment of Section 55 of the Principal Act to include the cessation of a body as a religious or secular body as a reason the registration of a person may be cancelled on the Register of Solemnisers. Section 55 provides for the cancellation of the registration of a registered solemniser by the Registrar General on a number of grounds, including a request for cancellation or that the marriage ceremony does not adhere to the necessary declarations. A registration may also be cancelled if the registered solemniser is convicted of an offence under the Act, or carries on a business solemnising marriage for profit or gain, or is not a fit and proper person to solemnise marriages, or for any other reason. Section 55 sets out the requirements for the Registrar General if he intends to cancel a registration. The amendment provides an inclusion of secular bodies so that their registration may be cancelled under the same criteria if required. The amendment provides for an inclusion of secular bodies so that Section 8 provides for the amendment of Section 56 of the Principal Act to include secular bodies in the provisions to appeal against refusals or cancellations of registration in the Register of Solemnisers. Section 56 of the Principal Act provides for leave to appeal to the Circuit Court if the Minister dismisses an appeal on the grounds that the body has ceased to be a religious body. This section provides the same rights of appeal to a secular body. If the Minister dismisses an appeal on any other ground, a party to the appeal may appeal against the dismissal on a point of law to the Circuit Court. This section provides the same appeal rights to a secular body or to a party to the appeal who is not a member of a secular body. Section 9 provides for the amendment of Section 57 of the Principal Act to allow for the granting of temporary authorisation to solemnise marriage to solemnisers from secular bodies. Section 57 of the Principal Act already provides for the temporary authorisation of members of a religious body to solemnise marriage. An application made by a secular body under this section will be in such form and containing such particulars as may be determined by the Registrar General. The application must be made by an officer of the body. The certificate must be furnished in a satisfactory form, stating that the person to be temporarily authorised is suitably trained and accredited as set out in section 45A 1E, and in the opinion of that person of standing is a fit and proper person to solemnise a marriage. In addition, this section will provide for the Registrar General to request further information regarding applications for temporary solemnisers from a religious or secular body. Currently, there is no provision for the Registrar General to request additional information from religious bodies, and this amendment will provide for such a request. Section 10 provides for the short title, collective citations, construction and any necessary commencements. This bill represents a significant and important change to the Civil Registration Act of 2004, which sees us as a nation recognise the increasing desire of people to celebrate marriage in a way that includes their own secular, ethical and humanist beliefs. Marriage is an important institution, and this bill enhances its role both in Irish law and in Irish society. And I welcome the bill before the House, bringing people who are members of a humanist organisation, as it were, into the group of people which up to now has been confined to civil registrars and to a whole wide set of religious faiths and religious bodies, and I commend the bill to the House.
Okay. Thank you, Minister. A call now on Deputy Willie O'Dea, who has 20 minutes.
Thank you very much indeed, Cathaoirleach. I welcome this bill. We have no notion of opposing it. In fact, we support it strongly. I understand that a lot of work has been done already in the Seanad on this bill by a number of people, particularly Senator Batchick, and I want to acknowledge that. On the surface, you know, in the great scheme of things, the bill looks unexceptional. It looks like something that doesn't make a great deal of difference, but in fact it does represent quite a fundamental change. Hitherto, only two institutions were enabled to solemnise marriage in this country, either a religious institution, as defined, or the state in the shape of the HSE. This extends the category of people who can solemnise marriage to what's called secular bodies. I think that, you know, on the whole, the bill allows differences to be accommodated. It makes our law more inclusive and more pluralist. As the Minister has pointed out in her opening speech, the proportion of people who are choosing a non-religious civil wedding ceremony as their choice of ceremony has grown quite rapidly in Ireland in the past 20 or 25 years and continues to grow. So, you know, as legislators, we must recognise that change and adapt ourselves to it. The term secular body has been fairly widely defined, as I can see from the legislation in section 3. It must be an organised group of people, not less than 50. The objects must be secular, ethical and humanist, must meet regularly, it must be in existence for at least 5 years, it must have a charitable tax status exemption of at least 5 years standing. And you know, to clarify the situation further, the section goes on to indicate what bodies are definitely not regarded as secular bodies for the purpose of solemnising marriage. Bodies like chambers of commerce, unsurprisingly, political organisations, trade union representatives, sporting organisations, and organisations which promote terrorism or carry on activities which are unlawful or contrary to public policy or morality. Now, despite this fairly extensive definition, there is still room for argument about what exactly means what, and I'm sure that, you know, that you know, probably in years to come, the courts will be exercised in trying to establish, you know, what in relation to that section, particularly on the objects that the body must have, what is secular, what is ethical, what is humanist. I think the original intention, as I understand it, was to allow the Humanist Association of Ireland to perform their own wedding ceremonies. Now, that could have been done, of course, by simply providing for that, providing an amendment to that effect and mentioning the association specifically. And, you know, I'm aware there's precedent for that. Now, the Minister has decided to go further, and as far as we're concerned, that's fine. I'm just wondering, was there some difficulty about not specifically mentioning the Humanist Association? If you look at the objects of the bill, there's a fairly broad hint as to what, as to the fact that the Humanist Association should be included within the ambit of secular associations. Nevertheless, I welcome the fact that you know, the Humanist Association will now, as a result of this legislation, be certainly entitled to perform their own, to solemnise their own marriage ceremonies amongst their own members. I've never been to a humanist wedding, but I have to say I was at a humanist funeral in Limerick recently, and I was certainly struck by the dignity and solemnity of the occasion. I was extremely impressed by that. I know that people of the humanist persuasion espouse an ethical philosophy of life. They are required to act with reason and compassion, and I've no doubt that many of them live their lives far better than people who claim to be members of particular religious organisations. So, you know, if the Minister could just clarify that, why she decided to go further, there may be some very good reason for it. Some of the organisations there are a number of organisations that can be refused access to the register as under section 45A2 on the basis that their objects are contrary to public morality or public policy or whatever. But of course, that's only in relation to a secular group. Insofar as religious groups are concerned, a religious group is defined in the original legislation, and the definition hasn't been changed here, as, and I quote, an organised group of people, members of which meet regularly for common religious worship, unquote. That's a pretty broad definition. It's a very broad definition. I know that in the Shannon debates, questions were raised about organisations such as the Church of Scientology, pagan associations, the Universal Church of Satan, I think was mentioned, and one doesn't regard it as being very desirable that they should be authorised to solemnise marriages amongst their members here because they simply happen to be part of a religious group as widely defined in the legislation. So perhaps the Minister could just clarify the position of those organisations in relation to this, in relation to the original bill as amended by this bill. So, you know, basically I welcome the legislation. I wish it a speedy passage through the House, and I think that despite the other problems which bedevil the country at the moment, it's good to see that Parliament can take time out to help the members of a very, very worthwhile organisation who, as I say, live their lives in accordance with the highest ethical principles.
Thank you, Deputy. Now call on Deputy Angus O'Snuddick, who has 20 minutes.
Well, Margaret, Minister, I'm not going to oppose this legislation. In some ways I welcome it, but in other ways I think we're treading a dangerous path here, and I'll explain the context of that remark as I go along. But I think the fact that we're here, I think, and the list of religions that are already authorised to solemnise marriage, I think, reflects our diverse society, especially in recent times. And I have attended quite a number of services, both religious and humanist, of a variety over the recent past in particular, but over my lifetime to date, and I find that every one of them is organised in an appropriate fashion. Some of what should be discussed in this legislation and discussion around it was probably more appropriate in a discussion about the Constitution, and some of it might happen with this constitutional convention that is due to start, but it's not one of the topics being discussed. So I'm not opposed to it per se, and in fact I welcome it for the humanists, but I think it is a bizarre piece of legislation, because we have already heard that the purpose of the bill is to extend the facility to become a marriage solemniser to secular bodies. And currently the HSE employees or religious bodies are the only ones to do so. I find it bizarre that, in fact, the HSE doesn't kind of facilitate people by allowing their staff to work at weekends where most of these services happen. That's a bizarre thing. If there's a need for an extra charge for weekend work, so be it. I just think it's bizarre. And that might have addressed a lot of the concerns that have given rise to this, that you would have the state body which is tasked with this available, and the state employees available to carry out that work without having to allow the devil and all in some ways to become a solemniser. The definition of a secular body around which this entire bill is strange in itself. It's a bit ridiculous, because the definition, a definition shouldn't have, or shouldn't really use the word it aims to define within that definition itself, because the following is extracted from the definition in section 3, which is trying to explain what a secular body is. A body shall be secular if it is an organised group of people and its principal objectives are secular. But nowhere does it define what secular is in itself. And neither does it define what ethical is, or humanist for that matter. And there is dangers when you go down this route in kind of being over kind of descriptive, but there's also dangers if you're not properly descriptive. It's also concerning when a definition relies heavily on reference to what it is not rather than what in fact it is. But that is a caricature of a lot of legislation. Defining secular body in section 3, it goes on to articulate a long list of types of bodies that are not secular. Many of these are in fact clearly secular to any normal person understanding, for instance, trade unions. Bodies that promote political causes, and again this list itself is vague, e.g. a political cause is not defined. Because, for instance, the Humanist Association of Ireland are a principal group which this bill will benefit, and as I said, I welcome that. But if you have a quick perusal of their websites, I'm not sure that they would even satisfy the definition of a secular body if that's the route they were going. Because according to section 3 of the bill, anybody that promotes a political cause is excluded from the bill's understanding of a secular body. That organisation's homepage has a section entitled campaigns, and inside there is one of the campaigns that they're working at is aimed at lobbying politicians to amend legislation. That's a political cause. That's the legislation we're dealing with. And in fact, it's good that they managed to get here, but by the own definition of this legislation, they should be excluded. Likewise, the text of the website is nothing but political in some ways, because it contains, for instance, a cheap shot at politicians with regard to holidays. It also has the inference, I take it, that the rest, from the rest, is that Fianna Fáil is bad and Labour Party is good, and Ivana Bacik is described as the perfect combination of lawyer, senator and atheist. And kind of, that's fine, but it is being political. And maybe she'd be the deity of the Humanist Association in the future. I'm only joking there. So, but anyway, sorry, that perfect. Well, we don't know. We'll see in the future. But anyway, it's the concerns I'm saying, that once you start kind of dealing with and putting in those type of restrictions, you then start to exclude. Or you could exclude some of the bodies you're intending to benefit. Atheist Ireland, for instance, is not happy. Not all atheists are or secularists, or for that matter, are humanists. And by limiting the definition of a secular body to humanists, lots of equivalently legitimate and credible secular organisations are potentially excluded from entitlements provided by the bill. And kind of Atheists Ireland have in fact said that they intend to challenge the constitutionality of this bill, and that's within their gift and the gift of anybody. But they have said in their letter, and they made a submission, very few groups made submissions or lobbied in relation to this, which I found strange, but they said they welcome the intention of the bill to make our law more inclusive. However, in practice the bill accepts and further institutionalises discrimination on the ground of religion or belief. It continues the discrimination in the act that it is amending, which is discrimination in favour of religious people and against non-religious people, and it adds new discrimination, this time being the non-religious people who have different philosophical and non-confessional beliefs. So it had a list of proposals which I didn't get in time to submit them, some of them as amendment because I agreed with them, but some others kind of to have a longer debate in relation to whether we should deal with them in the format that they had suggested. I am reminded of an episode of South Park in which Cartman, who simply can't wait for his new Nintendo, he transports himself into the future where the war is waging between the United Atheist Alliance, the Unified Atheist League, and the Allied Atheist Alliance. It might be the ULA, kind of it's into the future. But anyway, it's the same type of argument. I remember joyfully watching The Life of Brian when it was banned in this country, and it just shows how far we've gone as a society, that The Life of Brian was banned in 1979, and where are we now? At least we can understand satire a lot better. But anyway, in that you had the People's Front of Judea and the Judean People's Front, and kind of there will be occasions when within the religious groups and within non-religious groups that you'll have falling outs, and I see the bill even recognises that because it has a provision in it to allow for marriages to continue even after the cessation of or the ending of a religion, which is kind of a bizarre concept in some ways. But anyways, the drafters were very diligent in that piece of work. But Atheists Ireland are right when they say that this bill discriminates against non-religious organisations. They are also right when they say that the bill continues discrimination between the religious and the non-religious because of the criteria contained in that section 3, and where if you're a religious body and you have a deity, it's fine, you can get in one door, but you have to kind of jump through all of these other hoops, have 50 members and be 5 years in existence and carrying out the practice for 5 years before you can be recognised. So they have a point, and let them, if they so believe, go to the four gold mines, as I think the Phoenix calls it, in the future. And another deputy said that there might be problems in the future, that people will be inclined to go that way if they feel so discriminated. But by giving the power to solemnise the legal contract of marriage to bodies outside the state's own infrastructure, whether they're religious or not, I think opens ourselves to unsolvable and endless problems which could end up in court. I don't think that any legal definition can fairly answer the question, and therefore would be better not to have opened up some of this can of worms in some ways. My preference, as I said, is to move towards a situation where you have the state officials are the ones and the only ones who solemnise the marriage contracts. Religious services and religious organisations would carry out their own solemnisation of their religious contract, which is a separate contract. Deputies may be also familiar, and this is a point in terms of how dangerous it is going down the road of setting out a list of guidelines and what can qualify as a religion or not. I don't know whether anybody is familiar in this House with the religion of Pastafarian. Pastafarian, they have a deity which is the flying spaghetti monster. Now you might laugh, but this is quite factual, because a religion was created essentially in the United States to challenge the teaching of intelligent design or creatism in public school in the United States by way of a parody in 2005. But it has members, they said, that believe that a flying spaghetti monster invented the world and subsequently falsified the carbon dating tests to the by using the powerful nudie appendage. They believe that the pirates were the earliest worshipper of this flying spaghetti monster, and also directly correlate the global reduction in the pirate population with the rise in global temperatures and associated natural disasters. Now, it is funny if it wasn't so serious, because Pastafarian has become somewhat of a global phenomenon, with its members across the world using it to call into sharp focus the church and state divide. In July 2011, an Austrian Pastafarian won the legal right to wear spaghetti strainer on his head in his driver's license photograph. He fought his case on the grounds that Austrian regulations allow for the wearing of religious headgear in identity documents. So all I'm doing is cautioning, going down the road of all of the definitions of religion and non-religion in the way that we've done in this. There are other, in America it was used, Pastafarians also challenged and on occasion succeeded in having a tree with a spaghetti on the top of it have the equal status with the Jewish menorah and the Christian nativity seen in public buildings. So it has an effect, and sometimes the media probably focus in on that has political correctness gone mad, but this was a parody trying to expose some of how ridiculous some of the rules were. It is not my intention, as I said, to offend any religious or philosophical group. For me, the bottom line is this: all of this nonsense and the dodgy legal definitions that are contained should be avoided. It is important to note that marriage solemnisers were restricted to, if they were restricted to a fully accountable registrars are employed by the state under the Clorahor, then we would have a better system and we'd have a more secular society. It would be more in kin with a republic where we have equal status. Marriage is probably the most important and most prevalent legal contract entered into by citizens of the state. As in many other countries, people should have their marriage solemnised by an official of the state, and after that they are free to do whatever they wish, whatever ritual, ceremony or party that they like, religious or otherwise. They should be entitled to that. But for the purpose of the state, it should be a state employee to do that. There are other concerns that we could have if we had a longer committee stage section we could have dealt with. For instance, I mentioned the Monday to Friday rules with the HSE. There's the fact that even though in the legislation it says it shouldn't be for profit, it's that none of these groups should be for profit principally. They can be for profit, some of these religions or organisations that are set up, and that raises concerns. It is open, obviously, to a group such as people. I was very young at the time. People might remember the Screamers. That would have been a group of 50 people who worshipped on an island in Donegal, I think, eventually, who went around screaming their heads off as their release. But that was an organised religion, and if they screamed for 5 years, they might qualify under these rules to solemnise marriage. So again, another example, but in some ways a homegrown example of the Pastafarians and that. There was, I think, one or two other small points that I wanted to highlight. One of the points that have been made by Atheist Ireland is that it said that the description in relation to the excluded bodies and that is virtually taken en bloc from the Charities Act 2009, but where it says a body that promotes a political cause. and then it ends in this bill, whereas in the Charities Act, and don't forget this is kind of similar in some ways because it's the same type of rules that apply. A body that promotes a political cause, unless the promotion of that cause relates directly to the advancement of the charitable purpose of that body. Now, that would have allowed the humanists to do exactly what I was pointing out earlier if that part had been left in, because it directly related to the advancement of the charitable purposes of the body, and the charitable purpose of a religion or a secular group is to promote their ideals. In a religion, it's in religious organisations to promote their religion, and that might involve a political cause. In fact, if the Catholic Church wasn't on the list and it had to apply, it might fall foul of that because it is promoting political causes in some ways, or it is promoting causes which are contrary to public policy. So, for instance, we heard the bishops during the week on the government's announcement kind of saying that they were opposed to it. That would be contrary to political or public policy. So it's an area fraught with a lot of danger, and I do think it's a pity that we are dealing with it here today on the eve of the pagan festival of the winter solstice, and as the last item nearly before we break for the Christmas holidays. And that's interesting in itself that the humanists are going to benefit from our Christmas break. But we should have had a bit more thought in this. I know there was that the Senate had a long discussion on it and that, but I think it would have been useful to have a longer discussion in the committee in relation to this and all of the questions that have been raised by people, and maybe at a later date you might have to come back to this in another civil registration amendment bill to deal with some of the points that have been raised here and some of the points which Atheist Ireland have said that they intend at the very least to lobby the President to address or to prevent this legislation coming into law, because it contravenes quite a number of, in their view, quite a number of the UN conventions, the European Convention on Human Rights and the International Covenant on Civil and Political Rights, and also they say the Constitution itself. So, as I said earlier, it's in their gift now, because this is likely to be passed, to take that challenge. But I would have preferred if we had the opportunity to tease out those points prior to its passage, so that they wouldn't have felt the need at that stage to go to court. So I'll leave it at that. And as I said, I welcome the fact that we're addressing kind of the anomaly that the humanists weren't included in the first place, but we're addressing it in a way which I think is going to cause further problems for us in the future.
Thank you, Deputy. Now call on Deputy Finian McGrath. I believe the Deputy is sharing his time.
Deputy Matthew McGrath and Deputy Catherine Murphy. All right, you can stop me, Chair, after
equal
6
time
minutes.
each, yeah.
Well, 6 minutes will do me fine.
Sure.
First of all, I want to thank you for the opportunity of speaking to this new piece of legislation, the Civil Registration Bill 2012. I welcome this important bill and the debate on the new Ireland of 2012. I think it's important that we deal with change, that we enjoy diversity and difference, and above all, respect all citizens on this island. We also must respect all religions and those that have no religion, but at all times keep a strong separation between church and state. This civil registration bill and the broader debate gives us all an opportunity to try and build a real democratic and inclusive republic on this island. Recent events, for example, in Belfast, sadly, over the last few weeks and days, are not part of that process. And those involved in violence, threats of violence, intimidation and sectarianism have no place on this island and our shared future. I have to say that I was saddened and disillusioned by the deafening silence of the political establishment here in the 26th County, as that silence should never be an option when sectarianism or attacks on public reps is going on in this island. The disgraceful attacks, for example, on the Alliance Party in the beginning, and later other public parties and public representatives, was a disgrace, and those stirring it up should be ashamed of themselves. And I think it's important that we, regardless of political differences, that we stand out and say in this broader political debate, which is trying to be an inclusive piece of legislation, that we should always stand up against any kind of sectarianism or any kind of racism. I raise this today in this bill because I want to chart a new way forward for this country, and that is why I'm supporting the legislation despite some of the flaws mentioned by some of my colleagues. The bill itself amends the Civil Registration Act of 2004 in order to permit secular bodies, as defined in the bill, to apply to An Tóir Chláirithe for registration on the Register of Solemnisers. These registered secular bodies, along with the HSE registers and registered religious bodies, will be permitted to carry out legal marriage ceremonies. Trends in marriage over the last number of years showed a significant interest in civil marriage ceremonies. This bill and this legislation will permit for a wider range of civil ceremonies than those currently provided. The state is the only current provider of civil marriages, and I warmly welcome this. It's in relation as well to, it's very important to look at the context of this legislation. Ireland is changing, and is changing rapidly, and as far as I'm concerned, changing for the better when it comes to respect for different religions and people of non-religion. The non-religious wedding ceremonies, for example, in Ireland, the proportion of couples choosing a non-religious civil wedding ceremony in Ireland has increased from 6% in 1996 to more than 23% in 2006. The CSO has stated that in 2012, for the first time, the number of non-religious wedding ceremonies may exceed the number of religious ceremonies. Evidence from the CSO shows that Ireland, the numbers of persons of no religion, continues to rise. And in Census 2011, the second large response to the question on religion was from those who identify themselves as having no religion. I think it was in the region of over 270,000 people ticked the no religion box. That's up 186,000 in the 2006 census. So we have 270,000 people who ticked the no religion box. So what I'm saying is, in a broader, inclusive republic, this has to be recognised, and this legislation is a step in that direction. In relation to the issue of the Humanist Association of Ireland, humanism is an ethical philosophy of life based on a concern for humanity, which combines reason with compassion. I think there's two key words there, humanity and compassion. And I think it's not the public property of any particular religion. It's basically, you can have these qualities in a lot of different religions and also in the humanist tradition as well. Humanist wedding ceremonies already have legal status in countries like Scotland and Australia since 1972, and I also believe in the Scandinavian countries. In Ireland, a growing number of couples seek to have humanist wedding ceremonies, even though these currently have no legal status. A total of 153 humanist wedding ceremonies were celebrated in 2011, and close to 200 ceremonies were celebrated by the end of 2012. There are now 12 accredited celebrants performing non-legally binding humanist wedding ceremonies in Ireland. So this is the background to the legislation, and I think it's important that we deal with this situation. In relation to the details of the bill itself, the bill aims to allow humanists and similar groups to conduct legal civil wedding ceremonies. And again, I think this is an important step, and it's also a very important detail about what's going on in Ireland at the moment.
The Deputy has 1 minute.
This bill is to amend the various sections of the Civil Registration 2004 Act, which regulates the registration of civil marriages. So, again, this is important in this debate. It's very, very important in relation to it. We also should never take religious and civil and human rights liberty in any state and in our own state for granted. These are principles that we all should be prepared to defend and protect for everybody. Finally, I welcome the publication of this bill and will be supporting the legislation, as it is part of the reform and change process on this island, and reflects the view of a new Ireland that respects all of our citizens in the tradition of Tone Connolly and the late Tony Gregory. Thank you.
Thank you, Deputy. Call on Deputy Matthew McGrath.
Good morning, Cahill. I too am pleased to be able to speak today on the Civil Registration Amendment Bill 2012. And whilst a bit of critic, I thank the Minister for getting her to this stage, because we have had such a hectic session, in fairness, this year, and with all the different bits of legislation. I suppose it's peculiar, to say the least, that we're discussing this evening after just a fraught 10 days with finance bills and property tax and whatever. And I see the list of people, Minister, that you are going to allow. You didn't bring the revenue commissioners into this hall. I thought you might have, after the property tax, you might have allowed them to carry out the managers also. The Civil Registration Amendment Bill will permit specific secular bodies to solemnise marriages. Presently, the power to solemnise a marriage is limited to registered religious bodies and to the HSE. As has been mentioned by many, that's very awkward for people, because if they want, most people, weddings traditionally are most often are in weekends, for people to visit and whatever from abroad. It's very difficult if they can only done Monday to Friday during working hours. And as I said, it also reflects, the change of views and change of religious practice and everything else in this country. And indeed, our most recent census, you pointed as well, that so many people tick the box for non-religion. So it's important that we reflect that, to be, I suppose, in here to legislate for all our citizens to the best of our ability. And for example, in 1994, civil marriages accounted for just 5.11% of all marriages. By 2009, civil marriages accounted for 28.7% of all marriages. That is a telling figure in itself. This shows that there has been a marked shift in the relative proportion of civil marriages versus religious marriages. So we have to, I think, acknowledge that and try and reflect that in this legislation. And I think this is an honest effort in the bill to try and deal with that. But there is, however, a problem with the current legislation, Minister, and I ask you to take note of this carefully. The current legislation provides for the registration of a register. This needs to be clarified, as it does not provide the registration of a solemniser. When the Registrar General is acting as both registrar and solemniser, there is a serious conflict of interest. And I really believe this. Further, the Registrar General, in several correspondence with a constituent of mine, Mr. Niall Dennehy, is a Commissioner for Oaths in Clonmel, is refusing to register him as a solemniser, in spite of the fact that he has been appointed by the Supreme Court as a Commissioner for Oaths and empowered to officiate at the making of any solemn declaration within the state. So that needs to be clarified, Minister, I think, and he's not the only Commissioner for Oaths. So there is a discrepancy there that needs to be, I honestly believe, needs to be clarified. As I said, he can officiate at the making of any solemn declaration within the state, so why is he debarred in this particular